recording. Okay, everybody ready?
Yes, I am.
Okay. I'm just trying to get this right here. Okay. All right, we're here on case number, looks like 21-029-SPH. It's in the matter of Norman and Ellen Barton petitioners. They filed a petition for a special hearing. And that, well, just a little brief history. That went in front of an administrative law judge. Then it was appealed to the Board of Appeals. And then it was appealed to the circuit court. And then it was further appealed to the Maryland Appellate Court. Maryland Appellate Court issued an unreported opinion and remanded it back to the board to make a determination on whether it looks like whether the to address the fifth amended development plan. My name is Brian Pennington. Along with me is Mr. Fred Lauer and Ms. Sharon Bernardi. Just note, obviously, for the record, Ms. Bernardi was not on the original case. Andrew Belt was, and he's not on the board any longer. He's an administrative law judge, and Ms. Bernardi has had, I imagine, a difficult task reading through everything and catching up and putting herself where she is right now. So this is a public deliberation, and I believe we're here to deliberate what I just said, the remand issue from the Appellate Court of Maryland, which was addressing the Fifth Amendment development plan issue. Does that sound right to everyone?
Mr. Chairman, I would think that there probably are 4 matters that we need to consider. And I think to restate or clarify for the record going forward, if I might address those.
Sure.
And I can tell you why. I agree with you, obviously, about the fifth final development plan. But even though the Court of Appeals specifically asked about the application of the fifth development plan, I think for the record, we should address whether the 1990 restriction prohibiting the development on Track A in the case 1990-183 case should be removed. The majority opinion, as you were part of that, said res judicata didn't apply. And in the order from the board, the order itself, the final language, denied the special exception request for the 1990 restriction being removed. Now, I think it was a sentiment of all the members of the board that 1990 restriction should be removed. I think Mr. Belt addressed that in his opinion, but I think we ought to reaffirm that here just to be clear. The second thing is if I might here, I jotted down a couple of things. Second thing is, does the lot qualify as an existing lot under section 1A 078B4? I think I got those numbers right. And the board, the majority opinion, again, said yes, that it did qualify, and I think we had an expert there. However, the board denied that in the order that was remanded, okay? Even though the Court of Appeals said just address the fifth development plan. So I think we ought to specifically clarify and point out in our opinion or our discussion here today that this board affirms that, or however we want to do that. The third is the fifth final development plan, the application. I'm sure we'll get to that. But the other thing that I think we need to make clear for the record is whether further evidence, testimony, memorandum, or whatever are necessary for us to proceed. And I think as we go through our discussion, we can kind of get to that. But I feel that we need to somehow say whether we need that in terms of going forward or not. So those are the four things that I have. The fifth final development plan, whether we need any other testimony, evidence, hearings, etc., the restriction that was in the 1990, and whether the RC 6 district allows for this single family development. That's kind of how I see it, Mr. Chairman.
Yeah, I agree with you, Mr. Lauer. Obviously, I think once we discuss the issue remanded to us by the appellate court, then obviously once we reach a resolution, then where do we go from there, right? So
Right.
I agree with you that we need to button up the I guess the hearing, the case, and come up with a final resolution. And I think we already did. As far as
I think we did too on the
I
two
think
main
we just
issues that were
clarified all.
presented to us. Yeah.
Right. And so your fourth issue with regards to whether we need any additional testimony, briefing, memorandum, anything like that, I imagine we should probably discuss that first, right?
Sure. Sure.
Okay. I mean, I'll just give you my opinion. I don't feel that it's necessary personally. I think the voluminous documents and testimony, which we've heard and read and reread the transcripts and all the memorandums and all the orders and opinions from the courts, I think I have enough. I know what the issue, in my opinion, I think I know what the issues are, and um, I think I have enough to reach resolution. What do you think, Mr. Lauer, Ms. Minardi?
Yeah, I agree. I agree also. I think there's enough there from the hearing. I think if we had another public hearing, we would just be repeating what was given to us previously and what was in the memoranda, et cetera, that we had, the exhibits that we had. So I don't feel that, but I am glad that we are addressing it so that we make it clear to everybody kind of where we stand with that. Now, Ms. Bernardi, I don't know your opinion on it.
I'll quote the higher courts. We received excellent memoranda, so I don't believe we need additional testimony either.
Okay.
Okay. All right. So I guess maybe we should go with the final development, the fifth and final development plan issue, which was remanded to us. Is that fine with everyone to go over that first?
Sure.
Okay. And I know, yes, we addressed it. We addressed it in our public deliberations. Based on the transcripts, not pretty extensively, but it just never, it never made it into the opinion, which became obviously the official record. So I am of the opinion that the issue of the fifth development plan and how it came to be was not before us. I mean, we had a special hearing where we were, acting as a quasi judicial body to basically make a declaratory judgment. And that's what the special hearing is. We had two specific issues before us, and you mentioned them already, Mr. Lauer, whether to remove the condition from the 1990 case that prohibits development, and then whether the lot qualifies as an existing lot under BCZR 1A07.8B4. Nothing else was filed as far as in any petitions or anything like that. So we heard a special hearing. We were sitting deciding on a special hearing. The development plan has its own section, has its own way of, like I said, coming into being, and there is a procedure for that. There are appeal rights for that. And none of that was done. It doesn't seem like, it doesn't think anything was appealed. And the issue was not properly before us. I know I'm repeating basically what we said in the public deliberation, so, but that's how I feel.
I would agree completely, Mr. Chairman. I think Mr. Belt in the public deliberation on the matter was very clear. Several times he mentioned it. And my framework for it is that a special hearing really kind of sets the table. They're asking us for basically a declaratory judgment on these issues. And those were the two issues that were presented to us. Now, as we all know from past hearings, other issues come up at hearings. But the main focus and what we are to determine is the two issues as in the application or the petition for the special exception. So I agree with you completely, Mr. Chairman, that this was not properly before us. And as Mr. Belt said, there's perhaps another form, another way to address this, but it was not through this petition.
Okay.
And I concur with both of you, and preparing for this and catching up, relied very heavily on those transcripts. And you did have this discussion extensively.
Okay.
Okay.
All right. So I assume we're in agreement that the fifth amended development plan, final development plan, was not properly before us.
And I think there was a distinction trying to be made in the two memos that we got for the parties. And I guess the wording we're agreeing upon is saying it's not properly before us. Is that
Correct.
Yeah,
I mean, I'm not ready to make we're not in any position to make any decision as to whether it
correct.
was properly done. It wasn't before us.
Right. Got it. Okay.
Okay. So you want to go next with your first one, the 1990 restriction. That's the res judicata issue, correct?
Well, yes.
I
Yes.
mean, yeah. So, I mean, it's pretty clear to me in the appeals court's decision. I mean, they basically, obviously, they said res judicata does not apply in this case. So as a result, the 1990 restriction imposed by the zoning commission has been rendered ineffective by the zoning the Barton's property to RC6. So I think basically that we're basically being told by the court that, yeah, the 1990 restriction can be and should be.
Well, I don't know if they said should be. My distinction here, Mr. Chairman, just to clarify for the record, is they said res judicata doesn't apply. Okay, fine.
Yeah.
But where does that leave us? It leaves us, in my opinion, back to okay, should, based on special exception in 502.1, is there any danger to the health, safety, welfare, and all those other criteria that are in 502.1 in removing that restriction? That's how I look at it. And my opinion on that is basically that there isn't, and we should remove that 1990 restriction.
You mentioned special exception, special hearing, right?
Yeah, special hearing.
Right, 500.7.
Oh, I'm sorry. I cited the wrong thing. I apologize. Yeah, I'm sorry.
That's okay. Right, and I believe, and I think, if I recall, and I've read so much stuff, but I'm pretty sure we basically said that in our original opinion. But for res judicata, we would remove the restriction.
Right.
And
Right.
I agree with you. I mean, so I think because of the zoning change, the restriction, we can just remove the restriction.
And I agree with both of you, and that is important with Mr. Lauer's statement that and yours that the court does not want us to have res judicata be the rationale for making a decision. And so removing that issue, then we reached the conclusion based on the, was it 500.7?
Right.
Okay.
Okay, so then that leaves us with the last one, the property qualifies as an existing lot under BCTR 1A078B4. And I'm pretty sure in our original deliberations and our original opinion, we said that it did.
You
And
did.
I mean, I think we provided pretty good analysis on that issue.
Yeah, page 7 of the majority opinion, I think, stated basically that this qualifies as an existing lot.
So,
That's what I read.
right. And
Okay,
I'm still the
so
same.
we'll affirm that basically is what we're,
Yeah.
Right.
yeah,
Mhm.
okay.
Is that it?
That's all I had, Mr.
That's-
Chairman. I
okay,
don't
so
know
we
if there's
addressed all
anything else
four.
we need to.
I don't think so. I think we addressed all four of the issues. So I think we are good. Does anyone else has anything to say?
No, I'm
No,
fine,
issues.
Mr. Chairman.
Okay. All right, so we will adjourn this public deliberation. I'll stop the recording now.